Let us look at this tension that is mounting in Abuja over the decision of Rivers State House of Assembly to probe the finances of the state under the last emergency rule. Because that the emergency rule just ended, and the House of Assembly have decided that they will probe how the sole administrator, Ibas, spent over 200 and something billion that accrued to the state during that period. But in a surprise twist of events, the sole administrator, Ibas, is rejecting the probe. And as we have it, he's saying probing him will amount to probing the president who appointed him and the National Assembly who presided over the affairs of the state in terms of legislation during that period. But again, I know that clear conscience fears no accusation. So I don't know why the man will be trying to block the probe. But again, I'll bring you up to speed with what the Punch is saying about this. Do not forget, we equally want your own opinion with respect to this. Let us know what you are thinking about this. But let me get you what the Punch is saying about it. He said, Ibas reject assembly move to probe 6 months spending. He go further to say that the immediate past Rivers State Administrator, Vice Admiral Ibas, retired, and the Rivers State House of Assembly may be gearing up for a showdown following the latest decision to probe the state's expenditure over the last few months under the former, the Punch reports. He said Ibas is to be the administrator of the oil-rich state on September 17. Speaking further, it says the Rivers State House of Assembly presided over by Speaker Martin Amaule during his first plenary after the end of emergency rule said it would investigate the state expenditure during the 6 months of emergency rule. According to the resolution of the House, to explore the process of knowing what transpired during the emergency rule with regard to spending from the Consolidated Revenue Fund for the award of contracts and other expenditure. Finding by the Punch, showed that Rivers State received at least 254.37 billion naira from the Federation account, for the Federation Account Allocation Committee between March and August 2025. And this is where it gets tricky, where Ibas is reacting. He said Ibas kicks, reacting to the House of Assembly's move to probe expenditure under his tenure. Ibas said the lawmakers lack the power to investigate him, pointing out that they didn't appoint him as the administrator of the state. Ibas, while answering questions from our reporters through his senior special advisor on media, Hector Ibikiobu, on Sunday, said it was understandable that having been away from the business of legislation for a while, the lawmakers were merely trying to make an effort to discharge their functions. He, however, described the lawmakers' resolve as commentary, adding that the attempt to probe the former administrator was tantamount to probing the president who appointed him, as well as the National Assembly who supervised the activities of Ibas as his administrator as he then was. But let me quickly say that, contrary to the opinion of Ibas, I don't think this is correct. Even though the appointment of Ibas as administrator is a subject of litigation, because we are still waiting for court to make a pronouncement based on whether it was right or wrong, whether the president had the power under Section 305 of the Constitution to remove a sitting governor through emergency rule. But the question is, even if the president was even right to appoint him, does that amount to probing the president if the House of Assembly decide to probe him? I don't think so. Because we have instances where ministers were probed. We have instances where appointees of the president were probed, and the person could be indicted and sacked. We have seen that happen in several times. We have seen that happen severally in Nigeria. So it doesn't amount to probing the president. I think we must set that record straight, that if there's any need to probe, Ibas should be ready to answer questions, because he's the one that managed the state during that period. So if you know his hands are clean, he should be willing and ready to surrender himself to any process that want to ask questions as regard with respect to how the money that accrued to the state was spent during that period. And again, let us not equally forget that as we speak, it is not yet certain whether the whole exercise would be, at the end of the day, declared illegal, because we understand that that case is still pending before Supreme Court. Though I don't know whether the Supreme Court will have the courage to give judgment in that case, because we have seen instances in that we have seen similar instance in the past under former President Olusegun Obasanjo when he declared state of emergency, I think precisely in Plateau. We understand that why the case went to court as at that time. The then so administrator of Plateau State went to court to challenge the suspended governor that he lacked local standing to institute the legal action as the government of Plateau State having been suspended, and as such, in the wisdom of Supreme Court, the Supreme Court ruled that the suspended governor have local standing to institute such action. As such, they didn't dive into the legality or otherwise of the suspension. But this time around, the suspended and now reinstated governor of Rivers State, talking about Fubara, was not the one that instituted the action. They might have learned from that mistake in the past, because then Supreme Court relied on technicality to knock out the case, perhaps because they did not want to be in the bad book of the executive. But this time around, it is the PDP Governor Forum that approached Supreme Court to say, rule, decide, declare, determine whether, going by section 305 of the Constitution that gives effect to the president to invoke state of emergency, whether that section empowers the president to remove or rather suspend an elected governor, House of Assembly members, and all of that. We understand that in the past, the Jonathan did a similar thing, but the difference is that when the Jonathan did it in Borno State, Jonathan government did not remove a sitting governor. They merely suspended some laws to enable the military movement for quick action to address the insecurity occasioned by terrorism. Because even recently, the former governor of Borno State and now the vice president, Kasim Shettima, came out clearly to point out that in his time as governor, and of course he's the one that was the governor then under Jonathan, that Jonathan wanted to remove him through emergency rule. That Jonathan was advised that, going by section 305 of the Constitution, that he lacked the power to remove an elected governor. And at the end of the day, that government of Jonathan suspended some laws to enable the military movement to address the security and allow the governor to remain in office. So it's still not yet clear whether the judiciary will give judgment on this, or at the end of the day, the case will be withdrawn from court. Because the way it is, once you are the president in Nigeria, you are like a tin god. Your word is like an injunction. Nobody dares to say anything contrary to your opinion. But I want to say that the judiciary should know that the common man rely on them. And when it borders on issue of interpreting the law, it is in their purview. They should only realize that the same law, constitution that gives effect to the office of the president, gave effect to their various offices as people who are saddled responsible of adjudicating over cases. That is to say, in issues like this, they should not entertain any fear. Because today, a trouble is in Asura. Even if you govern for 8 years, at some point, someone else will be in Asura. So we should strive as a people, as a country, to build strong institutions rather than strong individuals. Because as we have currently, what we have is strong individuals rather than strong institutions. A situation where a former governor can be giving House of Assembly members orders how to conduct their business, that they must accept everything that comes from an incumbent governor, whether they know it or not, that they should not ask questions. And you can clearly see them sitting on the floor, and the former governor was drawing his ear, and he was ordering them, and they were answering yes, sir. I must say that is not healthy for our democracy, because the legislative arm of government, by our standard, is supposed to act as check and balance to the executive. But if we now have a situation where the House of Assembly members are taking orders from an individual, I must say that's a pure subjugation that must not be encouraged in a democracy. Because personally, I was thinking that we have grown past the era of godfatherism, the era of the Adedubus, the strongman of Ibadan politics, the era of the Sarakis of Kwara State, the era of Iboli dynasty in Delta State. I was thinking our democracy have evolved beyond that. But with the current trend of things, it looks as if we are just starting. And for me, it is not healthy for democracy. Because the whole essence of having three tiers of government, no, the whole essence of having three arms of government is for check and balance. We understand that the executive, of course, leader going into all their responsibility is to execute project and implement whatever appropriation comes from the legislative arm. On the other hand, the judiciary interprets the law, while the legislature, of course, makes law and oversight the executive. Now, that oversight power of the legislative arm in most states and even at the federal level have been taken away. That is why a state governor will act with impunity. Power, they say, corrupt, absolute power corrupts absolutely. So by the time you erode the oversight power of the legislative arm, definitely you are giving the executive an absolute power. And once that happens, of course, they will start acting with impunity without recourse to whether they will do the right thing or not, without recourse to whether they will do people's oriented project or not, because certainly they know that nobody is questioning them. And the only people who can question them is the legislative arm that have the power, the right to do so. Because by our standard, if the legislative arm appropriates and executive, of course, will execute, it behoves on the legislative arm to oversight the executive to ensure that the process of executing the project, they will make sure that the project meets specification. Where if they refuse to meet specification, they have right to question because they are the one that are appropriated. But the situation where the legislative arm members are now sitting on the floor taking orders from a former governor, directing them on what to do, that they should not ask questions, I must say is not healthy for democracy, and it must be addressed so that the government can belong to the people. Because according to the definition of democracy, that the government of the people, for the people, and by the people. But from the trend we are seeing, it's no longer by the people, it's not only by some powerful individuals. So in all of this, we must strive as a people to build strong institutions rather than strong individuals. Because strong institutions will endure. Strong individuals will fade away, but for a short while. Life itself is ephemeral in nature, it's transient. Because as we speak, all the former strong men of politics in Nigeria are no more. But in these institutions, they fail, they refuse to strengthen, are still enduring. And the society is suffering as a result of the inability of our system to strengthen those institutions that will endure over time. But I must say very big thanks for your time. This is Mr.